Hey everyone, it's Shauna the Tax Goddess. I am so excited to bring you today's video because this is a very pertinent topic to what's happening right now. Now, listen, preface here. This is for Arizona businesses, Arizona landlords, Arizona tenants. If you live in another state, we are going to cover some of the federal information here, but you do need to check with an attorney in your own state. So today's video is on Arizona. Now, I want to introduce our fantastic, brilliant real estate expert. This is Dennis Brookshire. So thank you so much for being here, Dennis. Dennis is the man here in Arizona. Let me just preface it by saying that Dennis is the man here in Arizona. We are going to be covering two of the major questions that we're getting from you guys. Okay. First one, if I'm a landlord, Dennis, right, and my tenants are not paying or they've just left, they dropped off keys in my inbox, right? What am I supposed to do if I'm a landlord? So that'll be the first question. Second question is, if I'm a tenant and I've been impacted by this COVID, by all of these crazy things going on, if I'm a tenant, what do I have to do? What are my requirements as a tenant to make sure that I'm not evicted, to make sure that I'm following the law? So I'm going to I'm going to let our amazing expert, Dennis Brookshire here, jump into the topic. So Dennis, let's start with, I'm a landlord. What do I need to be doing? What do I need to be concerned about? And take it away. Tell us all good things.
Well, thanks, Shauna. The issue for landlords here in Arizona is the impact of the CARES Act that was adopted by Congress, as well as Governor Ducey's executive orders. Governor Ducey adopted two executive orders, one March 23rd and the other April 6th. The first one has moratoriums for residential evictions, and the one adopted on April 6th has a moratorium to some degree for commercial evictions, and the guidelines and parameters are materially different. And those two executive orders are materially different from the federal act for the CARES Act. So I'm going to touch on first the federal act. It prohibits evictions both for single family evictions as well as multifamily evictions. The difference in the federal law is that it doesn't matter the status of the tenant, meaning that they don't have to prove up that they're suffering from COVID-19 or any of that. The moratorium is broader, and it prohibits an eviction basically on a residential property, whether it's single family or multifamily, depending upon the nature of the property. It's a covered property test under the federal law. And basically it's got to be a residential lease, that goes without saying, I guess. And if that property has a loan on it, that's a federally backed mortgage or other loan.
So almost everything. Like an FHA, that's what you mean?
FHA,
okay.
Freddie Mac, Fannie Mae, SBA, any federally affected loan, if that's on the property, then the federal moratorium applies.
Got it.
And that says that you cannot enforce or take eviction action if you have that kind of a property. The issue for the federal law is, though, there's no penalty to the landlord if they violate it. There's no enforcement mechanism. So basically, yeah, the law applies, but what's the penalty? Absolutely none. The CARES Act moratorium for evictions expires unless extended on July 25, 2020.
Okay.
So
basically our landlords then, I mean, they can do whatever they want, but technically there's a law in place until the end of July. Okay.
With no penalty to the landlord.
Okay.
I would guess that when we touch on briefly the Doug Ducey's executive order, when you're in eviction court at the justice courts here in Arizona, that might be a basis for a tenant to raise, hey, he's in violation of the CARES Act. That might be, from a tenant standpoint, something to raise, and we can touch a little more on that when talking about what the tenant's remedies are. Governor Ducey entered Executive Order 2020-14 on March 24, 2020, and that's the moratorium for residential evictions. Now, who does this protect? Well, this one, unlike the federal law, is determined based upon the status of the tenant. And it prohibits evictions by, actually, I want to clarify that. It prohibits the enforcement of an eviction by the landlord for certain tenants. And those are tenants that are required to be quarantined based upon a diagnosis of COVID-19, means you're going to have a medical diagnosis to prove that. It's got to be an individual that's been ordered by a licensed medical professional to self-quarantine because they've demonstrated the symptoms of COVID-19. So that takes another doctor's order to prove that up. It's got to be an individual that's required to be quarantined because someone in their household has been diagnosed with COVID-19. Again, you're going to need the medical proof then that you're caring for someone in the house that does have that diagnosis. You have to be able to demonstrate that you have the risk characteristics, older age, heart disease, lung disease, that kind of a thing. Again, that's going to take medical proof if you're going to base on that. Or the big one that I think everybody has been mostly trying to do is the individual has suffered substantial loss of income resulting from the COVID-19.
So
that includes
their job
loss, reduction in compensation, closure of your employment, obligation to be absent from work to care for a homebound school-age kid.
Okay.
And then the other catch-all or other pertinent circumstances, and that's not defined. So that would basically let the judge pretty much consider anything else subject to reasonable proof. The act says that, okay, if you're suffering from any of those circumstances, the tenant, if they want relief from the landlord, has to notify the landlord in writing with all the available supporting data to substantiate one or more of these criteria that would justify the prevention of the enforcement of the eviction. The issue here is that most tenants aren't providing that information to them. It's really not up to the landlord in any event to say yes or no. And I'm going to guess many landlords are going to say, I'm not persuaded, and proceed forward, especially if they're not getting paid the rent. So the act or the order says that the landlord can't terminate the lease based solely on the information that the tenants provided to them about one of these COVID criteria.
Yeah.
That doesn't mean that the tenant is not in breach of the lease. If you fail to pay rent as a tenant, you're in breach. Landlord has its remedies under Landlord Tenant Act and or its lease with the tenant. What this does is it doesn't stop, even if the tenant gives the landlord this information.
Okay.
The landlord technically could go forward and go ahead and do its eviction, file the eviction with the justice court. Contrary to what the myth out there, urban myth, yes, the courts are open, right?
Good if you're a landlord, for sure, yeah.
They're constitutionally required to be open, all right? So
okay.
I hear all kinds of stories, oh, the courts are closed. No, the courts are open. Okay. They're utilizing COVID-19 protocols just like everybody else, but the courts are open, they have to be. Okay. And they are processing evictions.
Okay.
What happens here under the executive order is the landlord, no matter what the tenant has done, if they haven't paid the rent and the landlord's complied with the terms of the lease or the 5-day notice of non-payment, the landlord can still file an eviction action against them. Okay. If the tenant doesn't show up, the landlord's going to get his default judgment of restitution against that tenant. What happens then is if the tenant's still in occupancy, landlord's going to give them the notice to get out because of the judgment. If they don't, then under the law, the landlord can go back in 3 days and get a writ of assistance from the court authorizing the constable to literally go out and forcibly remove them.
Okay.
That's where the executive order goes into effect, because it says that you can't enforce the judgment if one of those factors applies. So the constable goes out, they don't know whether they can enforce it or not. Their job is to enforce the court's order that they've been given to enforce. So they're going to go out and serve that occupying tenant with the writ of assistance. Now the tenant once served, got 3 days to get out. Okay. If not, they will be forcibly removed by the constable.
Now, if we're already at that point, right? So you've gone through the judgment, the constable's at the house, the constable's giving you the thing. At that point, can the tenant then prove, like, wait, no, I have the doctor's note saying I'm COVID or whatever, right? That they meet one of these qualifications. Is there?
Well, it's going to be hard. They can give it all to the constable, and the constable will say, I'm sorry, I don't make that decision. Okay. You need to take that up with the court. And so if the tenant hasn't already brought that to the attention of the judge, they're going to have to fly in to the courthouse to that judge and say, wait a minute, stay this enforcement because I've got one of the criteria that applies under the executive order. If they don't do that, then the constable can literally enforce the order and remove them. Yeah.
Okay. So if you're a landlord, you want to make sure, I mean, to the best of your ability, you want to make sure that no one shows up at that eviction hearing, effectively, right? Because you want to be able to evict somebody if they're not paying, if that's what you want, all these ifs. But, and as a tenant, from the tenant perspective, you better make sure that you're at that eviction hearing with the proof of whatever, that you meet one of these qualifications.
Yeah, if you're a tenant and you believe that the executive order applies to you, you better be showing up at that first hearing that the court schedules for the eviction process to be able to say, Judge, wait a minute, I'm protected by the executive order. Here's my evidence. The judge may or may not make an evaluation or determination at that point, but if the judge doesn't, they will necessarily set a hearing to evaluate that and make a decision. That's the time to do it. If you wait too long, it's going to make it much more difficult and less likely that the court is going to intercede and prevent the actual forcible removal. Now, in that executive order, and even on the media, Governor Ducey was encouraging landlords to work with their tenants, and the executive order references you can, encourage part payments and all those kinds of things. I caution landlords about doing that because if you don't accept a partial payment correctly, you will waive the ability to collect the rest of it later, because the Landlord Tenant Act under Section 3317 or 33-1371 specifically lays out how a landlord has to accept partial payment and preserve their right to get the rest of it later. And it has to be a written agreement done at that time with the tenant signing it, also saying how much is left owed and when that tenant's going to pay the balance. Okay. And if you miss any of that, 1371 sub A specifically says that the landlords waive the rest of the rent.
So guys, if you guys are landlords, this is exactly why you need an expert on your team. Do not be listening to the media, right? Ever, right? No. This is why no, did you see him just shake his head? Absolutely not, guys. This is why you want an expert on your team, right? Because if you miss even one little sub bullet point, you're done, you're out of money, and you're not going to get it, right? So this is huge. Okay. The
other dynamic is, of course, from a landlord's perspective, you don't have to do an eviction if the tenant voluntarily vacates the property, basically a surrender. That doesn't mean they haven't breached the lease. It just means that you don't have to do an eviction to gain possession of your property. If a tenant abandons the property under Arizona law, the landlord's authorized to go in and retake possession. So from a landlord's perspective, if the tenant is saying, I can't pay because blah, 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 landlord can say, well, all right, you can, go ahead and vacate, turn over the keys, et cetera, et cetera. Don't even have to talk about a breach, even though it's a breach. Just get possession, get the keys. Now you still have the right to sue the tenant for breach of contract, the lease, and sue them for all the rent. And that is not at all prohibited under the moratorium.
And that's because they left voluntarily.
Right. The only thing the moratorium does is prevent enforcement of a judgment of restitution if certain factors apply.
And that they've been proved. Not just that they apply, that they've actually been proved to the judge in that court. Okay.
Yep.
Huge, huge, guys. Okay.
So if the landlord can get a voluntary surrender by the tenant, perfect. Now the moratorium doesn't even apply to you. Something else, having represented landlords in Oregon and Arizona for 38 years, another dynamic to seriously think about is rather than get held up during the application of this executive order, to the extent that it might apply and the tenant might do the things correctly to get the prohibition on enforcement, landlord might seriously consider about agreeing to waive the breach if they voluntarily surrender, so you can at least get possession of the property and potentially relet it. Landlord might even induce the tenant to move out, give them a couple of $100 and say, hey, if you voluntarily surrender, I'll give you $200 or $500.
Here's your moving money. Here's
to get them out to voluntarily surrender. That's an economic assessment by the landlord. But given that the executive order runs through July 22 of this year, if not further extended, from a landlord's perspective, you're looking at another 3 months. So if you can get possession of your property and relet it in less time than that, that may be economically more advantageous to you as a landlord than trying to push through or ride out the moratorium with this tenant. So, because I guarantee you, if the tenant gets the decision that the executive order applies to them, they're camping in your house or property for free through July.
And heaven forbid they get mad about anything, destroy anything. I mean, there's a lot of good reasons to get them out of your property.
Well, the executive order does carve that out. It does not affect the right to get an immediate termination or eviction if they're doing some of the other bad acts that are prohibited under the Landlord-Tenant Act.
Oh, good.
Tearing up the place, doing criminal activity, any of those things, those are still, basically they're carved out as exceptions.
Okay.
So you may have one of the criteria or more for one of the COVID-19 grounds, but if
start
you're
destroying the
place
property
up or doing one of the emergency immediate grounds for termination eviction, those still apply.
Okay,
and the judge and the courts are specifically saying that they're going to do it. I just pulled the website this morning to make sure it was current, because these things are constantly evolving, on the COVID-19 procedures for Maricopa County Justice Courts. Now, this is just for Maricopa County, but if you're in other parts of the state of Arizona, many of the justice courts are all similarly following similar types of provisions or rules. And the court specifically provides that immediate evictions will still be held per the usual timelines as required by law. So again, if you've got another basis other than they just haven't paid rent, the courts are still going to entertain that. Further, the court has said a COVID-19 diagnosis or exposure may prevent an eviction judgment from being enforced. Just like I'm saying, it's the writ of execution, right? There is no order stopping evictions from being filed, and therefore the courts must accept those case filings, then set and hold the hearings. So the courts are telling you, yes, we're going forward on these. It's up to the tenant to queue us up if there is an application of the executive order.
So it's a perfect break, so landlords, guys, do what you can, talk to your tenants, but make your choices, right? These are all choices. And of course, work with a professional, right? Obviously, many landlords don't know all of the little details and all the little bits. That's why we work with professionals like Dennis. So Dennis, let's switch over to the tenant side. So you've made a very poignant point, right? If you get sent to go to court, show up. If you're a tenant, do not stick your head in the sand, right? But yeah, I mean, so let's look at this from the tenant perspective. What kinds of things, if I'm a tenant, what kind of things do I need to do to protect myself, to create documentation? Talk a little bit more about all that.
Well, the executive order lays out what you're got to be able to prove as a tenant. Again, the requirements can be any number of items, obviously. And let me pull that back up. Yeah. Again, like we said, the executive order requires that the tenant provide the landlord with notice of this stuff. So obviously, even if you do have to go to the court, the eviction court, the justice court, to prove all this stuff. But one of the requirements is that you provided the landlord with written notice of your issue with being protected under the executive order. So that's a condition precedent in any event that you've complied with that. You gave the landlord in writing the notice saying, hey, I can't pay because something under the act applies to me. And then you've got to have provided the landlord with that evidence. If you haven't done that, the landlord's going to come into that same hearing and saying, this is the first I've heard about it, Judge. So they didn't timely give me notice, and therefore they've waived. What a justice court's judge going to do with that, I don't know, but that will be the argument by the landlord is, hey,
sure,
they didn't comply with the executive order. I'm entitled to go forward.
So what counts as notice? I mean, an email, a voicemail, it said in writing. So an email, a letter, certified mail, what kind of things?
Well, the executive order, again, doesn't identify what constitutes a sufficient writing.
Okay.
I think the judges will give latitude if it's been sent an email or letter or otherwise, but under the Landlord-Tenant Act, unless your lease provides otherwise, the only bona fide legal notice is in writing by a letter delivered to the landlord by regular mail, not even certified.
Okay.
Other than that, unless the lease provides that you can provide notice in some other means, the act doesn't say that that's a valid notice. Again, the landlord could be potentially taking a technical position that, no, I didn't get notice. Certainly not.
But if that's going to give the landlord an out as to, I didn't get notice, per the lease agreement, I'm supposed to have it in writing via mail. I didn't get anything.
Or personally delivered. Yeah.
Okay, or personally delivered, and I didn't get either. So tenants, guys, step one, read your lease, right? Figure out exactly how you're supposed to be giving notice here. So then the second thing that you mentioned was timely. So is that 30 days in advance, or does that again depend on the lease, or?
Well, obviously, if you're not, this is fluid, obviously, as far as facts for each tenant.
Right.
They may be doing just fine. They may even be working still, and all of a sudden they get sick.
Laid off, or they get
sick.
They
get laid off, or they get sick, and they're diagnosed with having the virus.
Right.
So as soon as, I think from a tenant's perspective, as soon as one of the factors applies to you as a tenant, if it's going to impact your ability to pay the rent. Now, don't use it candidly, as a tenant, don't use it as an excuse not to pay the rent, because you're not off the hook ultimately. Legally, you owe that rent. If you can still pay it, you should be continuing to pay it, because if you don't, even if the landlord can't throw you out under the moratorium, they will ultimately throw you out. And if you take all 3 months and not pay the rent, if your rent's $1,200 a month and you don't pay for 3 months, at the end of July, you've got $3,600 in back rent due,
plus
plus
penalties, plus
and penalties, and plus now you got August rent due.
Yep.
That's a $5,000 bill that you need to write a check for. If not, you're going to get thrown out anyway. So, and tarnish your credit record if it's one of the larger property management companies that would do credit reporting and all of those kinds of things. So just because the act or the executive order might apply to you, if you can still pay your rent, you really should. It's not an excuse to get free rent, because it's not free rent. It's just deferred. It's just deferred.
Guys, as you guys know, nothing in this world is free, right? And if you are a subscriber to our YouTube channel or our Facebook group, you know that even the stimulus is not coming to you for free. Nothing is for free. So I know we only have a minute of your super valuable time left, Dennis. Thank you so much for all the information that you've given to us. Everybody, we're going to be putting Dennis's information, of course, in the video itself. But Dennis, where can we find you?
Well, we're my office here in Scottsdale, North Scottsdale. You're welcome just to give me a call at the office number. It's 480-991-9077. We're at Raintree in the 101. I think Shauna, you'll post my address and stuff.
Absolutely.
You're also welcome to just send me an email. In fact, that's usually better than trying to catch up with me on the phone. And my email, I'm sure, will be on the screen, but it's dbrookshire@hgplaw.com.
Beautiful. Thank you so much, Dennis. We really appreciate your time. And listen, guys, if you're a landlord or a tenant and you don't have a real estate attorney, you are hurting yourself right now, okay? You need an expert on your team. We love Dennis. Tax Goddess has worked with Dennis forever, 15-something years. We love Dennis. So if you need a real estate attorney and you don't absolutely drop dead love your person, call Dennis. Dennis is amazing. So thank you so much, Dennis, for your time. It's been a pleasure to have you. And guys, of course, we'll have all the information, and you can click on all the links and go see Dennis. And if you're not a member of our YouTube family or our Facebook group, join, because that's where we put amazing information, just like the handsome Mr. Dennis here, for all of you guys to learn. So thanks so much. Thanks, Dennis, for being with us, and have a wonderful day.
All right. Thanks, Shauna.